Good evening, viewers, and welcome to Elombah Television tonight. As you are well aware, on the 17th of September 2020, President Muhammadu Buhari signed the Nigeria Police Bill 2020 into law. The act repeals the Police Act 2004 to provide for a more effective and well-organized police force, driven by the principles of transparency, accountability in its operations, and management of its resources. Among others, the Act establishes an appropriate funding framework for the police in line with what is obtainable in other federal government key institutions. Since the signing of the bill, however, there have been several controversies with regards the effect on this bill on the powers of the police to prosecute crimes. Not just the police, the powers of other federal law enforcement agencies to prosecute crimes in Nigeria. Lawyers have debated the issue, and so tonight we have eminent lawyers in our midst to discuss this topic, tonight being the new Nigeria Police Act 2020, its effect on criminal prosecution. With us tonight is Mr. Sylvester Udemezue with us now. He's a lecturer and legal practitioner at Nigeria Law School, Victoria Island, Lagos, Nigeria. Mr. Udemezue, you are welcome to take the floor.
Right, thank you very much. I thank all of you and for the wonderful contributions we have been treated to so far. Now, I think I'm told that I have just 10 minutes to start the program, that's to talk. And I would like to start from the very first issue, which is with borders on the topic we have for discussion today. There are so many things to be said about the new police act. We can spend the whole day discussing that law. There are so many things, and I hope that the organizers of this program will make our time to take up all other aspects of this program. So I would like to start from this prosecution of cases by police officers. Now, having listened to the last speaker, Mr. Oba, my very big learned friend and brother, I would like to say that with due respect, the truth of the matter is that police officers are still empowered to prosecute cases in Nigerian courts. That is what the implication, the first thing that must be said, because we are not going to rely on only the provisions of the ACJA or ACJL of some states to decide whether police officers have the power now to prosecute cases in Nigerian courts. We also have to look at decisions of courts of law. And if we have to go down memory lane, we would discover that this all started with, of course, they have been prosecuting cases like Mr. Oba pointed out, that this started because we didn't have sufficient number of legal practitioners at the beginning. Just like even non-lawyers used to practice law in Nigeria. It was 1914 that the Supreme Court, the Chief Justice of Nigeria, banned all aspects of practice of law by non-lawyers. And it was Mr. Osho Davis who made an application to practice as a self-taught attorney. And the CJN refused that application and said the era of self-taught attorneys or non-lawyers practicing in Nigeria is gone. So I wonder, I am still surprised that non-lawyers were stopped as far back as 1914 from practicing law in Nigeria. But police officers who are not lawyers are still allowed to continue to practice in court, to continue to practice as if they were lawyers. Now, this is because a decision of the Court of Appeal in the case of Olushemo and COP, that Olushemo and Commissioner of Police reported in 1998, 1 Nigeria Weekly Law Report, part 575, page 547. It was in that case that the Court of Appeal declared that any police officer can prosecute a case or cases in all superior courts in Nigeria, but such police officers should have been called to the Nigerian bar. In other words, Olushemo and COP made it clear that for any police officer to prosecute a case in any court in Nigeria, he should have been called to the Nigerian bar to prosecute. If he had to prosecute a case in any court apart from inferior court, like High Court, Court of Appeal, and the Supreme Court, and you are a police officer, you must be a lawyer. That position was okay, but it authorized police officers to prosecute in inferior courts, like magistrate courts, area courts, and so on and so forth. Now, this continued until the case of Osaho, or Federal Republic of Nigeria and Osaho. The Federal Republic of Nigeria and Osaho. That was a Supreme Court decision in 2000, reported in 2006, yes. 5 Nigeria Weekly Law Report, part 973, page 361. It was in that case that the Supreme Court now declared, and I quote, that all police officers, whether or not they are qualified as lawyers, were entitled to appear and prosecute cases in all courts in Nigeria. So with that decision in Federal Republic of Nigeria and Osaho, the decision in Olusemo, which restricted practice by police non-qualified or non-lawyer policemen to only inferior court, was overruled. So the authority now became the case of the Federal Republic of Nigeria and Osaho. That meant that any police officer, whether you're a lawyer or not, can take up a case and prosecute from the magistrate court to the Supreme Court. There was no bar. Of course, I want to take our attention back to what Honorable Justice Oliver Wendell Holmes, of a former justice of the United States Supreme Court, said that the prophecies of what the court was, whatever the law is, whenever interpreted by the court, whatever court says about that becomes the portion of the law. So Federal Republic of Nigeria and Osaho continued to operate until when the ACJA in 2015 came on board.
That is it.
So the ACJA came on board in 2015. And when it arrived, it, of course, not to belabor this issue, because Mr. Oba has cited some provisions of the ACJA and also spoke about what the ACJA is saying. My conclusion or my opinion is that the ACJA has banned anybody who is not a police officer from prosecuting in the court where the law applies. But the truth of the matter is this: ACJA, Administration of Criminal Justice Act 2015, does not apply to all the courts in Nigeria. It applies to only few courts, the Federal High Court and the Federal Capital Territory. In other words, the ACJA, the Administration of Criminal Justice Act, does not apply to any state high court in Nigeria. It does not apply to any magistrate court apart from the magistrate courts in the Federal Capital Territory. So it applies to only 3 courts: the High Courts in the Federal Capital Territory, the magistrate courts in the Federal Capital Territory, and all Federal High Courts in Nigeria. So what about all the states in Nigeria? Their high courts, their areas, so on and so forth. What about those ones? Act 2015 has now banned non-lawyer policemen from prosecuting cases in any court to which that act applies. Police officers who are not lawyers have continued to prosecute cases in all other courts in this country. So not much progress has been made, if you look at it that way. While the Administration of Criminal Justice Act has done a lot of things to say, okay, police officers who are not lawyers should no longer prosecute. It must be said that until this is extended to all other states in this country, we will not say that police officers have been banned. That was the position. Now, there were a lot of writings from lawyers and interviews and programs, okay, people calling for that police officers should just be absolutely banned from prosecuting cases in Nigeria, because they're not lawyers and they can't handle cases that lawyers handle. They can't even prosecute. The truth of the matter is that police officers cannot prosecute cases except they are lawyers. If you're not a lawyer, you can't prosecute a case. And you can't face a lawyer in court, like Mr. Oba pointed out. You can't come to court and stand before a lawyer. Imagine Mr. Sylvester cross-examining a witness in the witness box, for example, and the police officer will be on the other side. We all know that when you're cross-examining your witness, there will be a point where the counsel on the other side will need to object to some things. So when I get to court, whenever I handle a case with the police, I say whatever I like in court. He can't do anything because he doesn't know what the law is talking about. So it is a very ugly scenario that we have police officers in this country prosecuting cases. So this continued, the position under the ACJA. I can say now that what the ACJA did in 2015 was to just a kind of ban prosecution by police officers in just about 3% or even 2% of all the courts in Nigeria. Because the Federal High Court and the courts in the FCT represent only 2% of all the courts in Nigeria. So what about the other 98%? It continued. So Ebonyi State and Kano State, in their ACJL, until today, the Lagos State government, or Lagos State that took the lead in the enactment of the ACJL, has not banned police officers from prosecuting cases. In Lagos State, police officers still prosecute cases in court. So the ACJL, the Administration of Criminal Justice Law, Repeal and Reenactment Law, Administration of Criminal Justice, Repeal and Reenactment Law of Lagos, 2011, did not ban police officers from prosecuting cases. So that continued in Lagos State. Now, Ebonyi State took some steps to try to ban police officers. Then there was this news that Kano State tried to, when they brought their Administration of Criminal Justice Law, that they also banned police officers from prosecuting. But when we now took a careful look at the Kano State Administration of Criminal Justice Law, it was noted that police officers were still permitted to prosecute cases. If I be permitted, let me read a section of the Kano State Administration of Criminal Justice Law as it is, so that we will see that in Kano State, although the news out there is that in Kano State, police officers, in fact, the AG, the Attorney General of Kano State, was commended for leading the fight or the crusade that led to the banning of police officers from prosecuting cases. Unfortunately, when you now take a look at the law itself, you will discover that there is still room for police officers to prosecute. I'm coming to the Nigeria Police Force Establishment Act 2020. I'm trying to just go down memory lane for us to understand what had happened before the 2020 Act. So that was why I personally, I am not happy with the 2020 Act, because a lot of things had happened. We expected much more than what the 2020 Act had done. Because today, the confusion still persists. That's my position. But I'm going to come to that. Let me just refer us to that position of the law in Kano State. And that is what many states have adopted. Now, section for Kano State. Just a second, I'm trying to bring it up. Now, yeah, the section 123, subsection 2 of the Administration of Criminal Justice Law, Kano State, provides, please permit me to quote verbatim, nothing in this section shall prevent a police officer from prosecuting any offense triable by any magistrate court. I repeat, nothing in this section shall prevent a police officer from prosecuting any offense triable by any magistrate court. That's section 123, subsection 2 of the Administration of Criminal Justice Law, Kano State. So with this, it is obvious that what Kano State has done is to repeat the position in Olushamo and COP. Police officers who are not lawyers can still prosecute at the magistrate court. And if they can prosecute at the magistrate court, they can prosecute at the area court, which is the equivalent to magistrate. This is also on the same level with the magistrate court. The only courts that police officers who are not lawyers are banned from prosecuting cases in Kano State are High Court, Court of Appeal, and of course the Supreme Court. So, which means in Kano State, police officers are still allowed. And as far as I'm concerned, Kano State has done nothing, because police prosecution is majorly seen at the magistrate court. So, if a law comes up and you still allow them to prosecute at the magistrate court, you have done nothing, as far as I'm concerned. So all the commendation and the congratulatory messages that were sent to the Kano State AG were over nothing. He has done nothing. When you allowed police officers to continue to prosecute at the magistrate court, and like Mr. Oba said, more than 70% of the cases at the magistrate court are frivolous because of this. Now, this was the position, and Administration of Criminal Justice Law of many states continued that way, and that was a very ugly scenario. So police officers who are not lawyers continued to prosecute cases in court until last month, when the Nigerian Police Force Establishment Act 2020 was signed into law by President Muhammad Buhari. And then looking at section 66 of that particular law, with due respect, I'm sorry, my very good brother and learned friend, Mr. Oba, I have to respectfully differ on this position. Section 66 makes it very clear that police officers can prosecute. Like you cited, you said the section 66(2) says a police officer may, subject to the provisions of the relevant criminal procedure laws in force at the federal or state level, prosecute before the court those offenses which non-qualified legal practitioners can prosecute. What this means, that section 66 subs 2. Yeah, a police officer, section 66 subsection 2. A police officer may, subject to the provisions of the relevant criminal procedure laws in force at the federal or state level, prosecute before the court those offenses which non-qualified legal practitioners can prosecute. Now, the question is, what is this section talking about? What is the implication of this section with respect to prosecution of criminal offenses by police officers? The use of may is automatically giving police officers right. If you say, Mr. Sylvester may come in, what it means is that I'm entitled to come in. In other words, if I want to come in, I can come in. If I don't want to come in, I should not come in. Once you say, Sylvester, you may come in, it's another way of telling me that, look, you are entitled to come in. So if you choose to come in, what that means is that every police officer who decides to prosecute a case in court today can still prosecute. And of course, we know that those police officers who are prosecutors who want to continue to prosecute. They will never want to stop because they know what they are getting. Corruption is on their head, with due respect to them. They are so corrupt, many of them, sorry to say that, many of them are so corrupt. All they're interested in is collecting money from defense counsel, from defendants, from complainants, and doing all sorts of shady deals. So they will want to continue to prosecute. So this section is a very, very setback on the administration of criminal justice in this country. It's a serious setback. So the section has continued to prosecute, has allowed police officers to prosecute. When you say I may prosecute, it's another way of telling me that I'm entitled to prosecute if I choose to do. In other words, it is left for me. If I want, I can. If I don't want, it's left for you. Now, let us take, it says, subject to the administration of criminal justice laws of the states. Let us take Kano State, for example. The question is, can a police officer prosecute in Kano State based on section 66(2)? The answer is yes. Because it says subject to the law. In Kano State, the Kano State law says no police officer who is not a lawyer can prosecute at the High Court. So in Kano State, application of the section 62 in Kano State now is that police officers can prosecute in all courts in Kano State apart from Superior Court. Because Kano State law permits non-qualified legal practitioners to prosecute. Although the term non-qualified legal is absurd, it is senseless, it doesn't have any meaning. I wonder where they got it from. But the most reasonable interpretation we can give to that term, non-qualified legal practitioner, is a person who is not a lawyer. Let us face the truth. If we look at it critically and reasonably, the closest definition of that term is a person who is not a lawyer. So what the act is saying is that police officers can still prosecute in all the courts where non-lawyers are allowed to prosecute by state or federal laws. So now coming to the Federal Capital Territory, that section cannot apply because ACJA has banned police officers from prosecution in all the courts. So section 66, subsection 2 of the Police Act 2020 cannot entitle a police officer to prosecute at the Federal Capital Territory because ACJA has banned them. Now, section 66, subsection 2 cannot entitle the police officer to prosecute at the Federal High Court because the ACJA has banned them there. But in every state in Nigeria where police officers have not been prohibited, expressly or impliedly prohibited from prosecution, section 66(2) they can still rely on section 66(2). That's the implication of the use of the word. Line with section 66 of section 2 of the Nigerian Police Force Establishment Act 2020 is that all police officers who are not lawyers may prosecute criminal offenses in any court in any part of Nigeria, provided that they are not banned or prohibited from doing so by the law in force in that state, period. In Kano State, for example, Section 66(2) authorizes the police officer to prosecute at the magistrate court, because Kano state law has banned them from prosecuting in high courts and other courts.
All right.
Thank
you very much. Thank you very much, Mr. Udemezue. Because
so this is what I think that my time is gone for this. I just wanted to start from that power of prosecution. So I will go to other issues as we progress. Thank you very much. God bless.